All right, howdy. Welcome to our panel on teaching contracts today. Is there anybody here from St. Thomas Law School here? Thank you all. This has just been an absolutely great conference. We thank you. We've got a great panel for you today. We're covering a variety of topics. I'm going to be brief on the introduction so we have more time for our speakers. They will go essentially in order. Professor Alan White, Law School of the City University of New York. He spent 24 years as a supervising attorney with Community Legal Services in Philadelphia. He is reporter for the Uniform Law Commission Committee on Residential Real Estate Foreclosures. Talk about a dull, boring topic these days. He is a member of the American Law Institute, past chair of the ALS section on creditors and debtors' rights, and has written extensively on consumer law, predatory lending, microcredit, and inequality in contracting issues. Next to him is Professor Candace Zierdt from Stetson University Law School. She's the former professor and dean at the University of North Dakota. She practiced with legal aid in Kansas City for 11 years. She was North Dakota Commissioner for the National Conference of Commissioners on Uniform State Laws, NCUSL, a member of the American Law Institute, and a member of the NCUSL Committee on Liaison with American Indian Tribes. She's written many, many books and articles, the latest, The Very Innovative Skills and Values for Contracts with Bill Woodward. Next to her is Professor Lucille Ponte from Florida A&M University School of Law. Before teaching, she worked as an in-house counsel for technology firms and government agencies in Boston and D.C. She's written extensively on a galaxy of topics, the main leitmotifs of which, she's written on almost everything, but the connection points seem to be alternative dispute resolution, intellectual property, employment law, and gender equality, with a lot of sidetracks into different issues. And she's also written for a very wide range of audiences, from the Columbia Journal of Gender and Law to LegalZoom.com. Her latest book is Cyber Justice, Online Dispute Resolution for E-Commerce with Tom Cavanaugh. Down at the end, Professor Tom Sullivan, who those of you from St. Thomas here will recognize. He is a professor and also director of academic support, oversees the active learning program for 1L students at St. Thomas. Before going into teaching, he worked at a Big Four accounting firm, worked in private practice, was general counsel and chief financial officer for a Florida-based corporation, and he's taught a galaxy of courses, including contracts, sales, commercial paper, property, legal accounting, and the art of lawyering. So with that, I will welcome our panelists and ask Alan to kick us off.
All right, terrific. Thanks so much. Thank you all for coming. So the motivation for the talk that I'm putting together here, and this is sort of a half-baked paper, not in a form of a draft that I was prepared to circulate yet, and I'm really very interested to hear comments from a lot of people who actively teach contracts. So I have a dual motivation, one which comes out of the actual challenge of teaching this material to students, and the other related to fields in which I still kind of have a toe in the world of practice, which is the area of contract modifications, where this doctrine still does a lot more harm than good. So the teaching motivation is that I find every time I go through the consideration material in a first-year contracts class, I am teaching students two sets of conflicting rules, as in the no pets allowed and all pets must be on a leash here. And this makes their heads explode, and it seems to me quite unnecessarily we have to go through this exercise. When you get past the theory behind consideration, you talk about actual rules that occur in about 7 or 8 common contexts, we find that, as to each one of these consideration-driven rules, there's probably an opposite rule that we have either in the second restatement of contracts or in various modern versions of rules that deal with these contexts. So we're trying to get our students to keep two completely conflicting sets of rules in their heads. In my last multiple choice portion of my contracts exam, I had a question about binding offers in which only 30% of the students got it right because they were all applying the common law consideration-based rule when I had told them in the instructions to use the restatement rule unless you're otherwise instructed. And they missed that little piece, and it was kind of an unfair question in a way. But okay, so that's part of the motivation. And I'm going to get to the practice-based motivation in a minute. Oops. Advance. Go. Okay. And the other motivation is that on a theoretical level, there are a lot of very interesting scholars writing about contract theory and can we find a unified basis for deciding what promises we enforce and which ones we don't. And consideration is just a really poor theoretical construct for making those decisions in modern contract law. And so you end up spending a lot of time on things like, can you contract around consideration by using nominal consideration that doesn't really exist and talking about peppercorns. And then you spend a lot of time trying to explain the difference between a conditional gift, Williston's tramp, and consideration. And I find as I sit with students after class in my office trying to explain this, I can't satisfy myself that my distinctions and explanations are satisfactory. So how could they possibly make any use out of this interesting but useless doctrine? Okay, so the outline of the paper I have in mind is to talk about consideration first as a set of rules, that the way the theory has been applied is to deal with, depending on how you classify them, 6 or 7 or 8 or 10 discrete problems. Mark Westman, for example, has written a couple articles about this and actually tried to look at what courts are doing as to each of these problems, the binding written offer and the post-contract modification and et cetera. And my contention is that for each of these issues, the modern rule, or the better rule, abandons consideration-based rules, and so that we really have this duality of the rule based on consideration and the rule that either most courts are using or most courts should be using. And in particular, I want to focus on the post-contract modification problem, where I think consideration doctrine is doing a great deal of harm and preventing us from thinking in more useful ways, whether we're thinking about it from sort of a deontological moral point of view or from a utilitarian outcomes-based law and economics point of view. Thinking about the modifications in terms of the pre-existing duty rule is just not a useful way to think about them. And then ultimately, the last part of the outline is, well, okay, how do we actually do this as teachers? How do we reorganize our syllabus in which we now spend half of the first semester in a 2-semester class, or a third of the class talking about this doctrine? We still have to say something about it, obviously. It's not going to disappear because we would like it to, although my hope is that if we stop teaching this to future generations of lawyers and judges, they won't be so obsessed with trying to derive rules from this doctrine. So first of all, is consideration doctrine predictive of actual rules in actual cases? And is it a useful way to distinguish promises that we should enforce and promises that we shouldn't enforce? So, just to pick a couple examples that raise or don't raise consideration issues, promise number 1, a pregnant woman promises to surrender her child for adoption to a married couple in exchange for the payment of $100,000. We should clearly enforce that under consideration doctrine, right? No problem. Promise number 2, after some negotiations, a wealthy donor promises to give $100,000 to a foster home for orphans, signing a written promise with detailed terms in the presence of her lawyer. Not enforceable, right? There's no social benefit to enforcing this promise. Third promise, 2 neighbors organize a potluck dinner. One promises to bring the entree, the other is going to bring the appetizer and the dessert. Well, under consideration doctrine, that's a contract. We should enforce that promise. This doesn't make any sense, right? And we use different categories of doctrine like public policy and other sort of workarounds. But if you think about consideration as kind of a unifying theory to distinguish promises that we enforce, promises that are exchange-based versus promises that we don't enforce, the ones that don't have some exchange involved, it's just not a useful way to think about which promises we actually want to enforce and which ones we don't. And so consideration arises, more or less repeatedly in these particular contexts, and I propose to look at each of these particular consideration problems and see what it is courts are actually doing. We have, of course, the sort of the illusory consideration problem, the extremely unbalanced transaction in the extreme, a transaction where there's really nothing being gained by one party, even though it poses as an exchange. This is Peter Minuit paying, a couple of dollars of wampum for Manhattan Island. And we deal now with those situations either by finding that there is actually a reciprocal promise that's not illusory, or we think about unconscionability and other doctrines, undue influence. So consideration doesn't really help us deal with extremely unequal bargains. Then we have the donative promise, the promise of a charitable subscription, in the famous New York case whose name escapes me right now. But the restatement approach in Section 90 is to say these are socially valuable promises that we should enforce, period. Unfortunately, the states, when you look at Supreme Court decisions, it's probably still a minority that have adopted, what is that, restatement 90B or C or 3, I forget, that says, charitable subscriptions should just be enforced without worrying about whether this is an exchange or not. 90 sub 2? Yes, thank you. So, this is an issue. Should we enforce a pledge that somebody makes to make a donation to a charitable institution? Consideration doctrine says no. Probably the better rule is yes. Then we have the old, promise in recognition of past services. The person is going to retire, and we've already paid them their wages for all their labor, but now we want to make them an additional promise. I think of this as sort of a variation on the post-contract modification idea, but consideration doctrine completely messes up our thinking about this. And the reality is, courts have devised some rules about when you should enforce these promises, notwithstanding the fact that they're not part of an exchange or a bargain. Then we have the third-party co-signer, the guarantor, particularly the inessential guarantor. When the bank says, well, we would make you the loan, but if you could get your wife to sign, then we'd really be excited about making this loan. And there, the restatement has adopted a pretty straightforward solution of saying if you put it in writing, it's enforceable. And this is the category of consideration rules that tripped up all my students on their final exam. That is probably a rule that is still a minority rule, as best I can tell. And part of this project is for me to try and update the case law in all these areas. Courts are still kind of stuck on the idea that we have to look to see whether there was a separate an exchange, whether that third-party guarantor was necessary to the transaction. Is that really useful? I don't know. There's the binding written offer problem. Whether somebody who makes a promise that they will keep their offer open and not revoke their offer, is that something that can be enforced without consideration, without payment? There again, the restatement says, sure, of course. If these are useful promises, put it in writing, commit yourself. We can distinguish between sort of casual promises and serious promises in other ways, other than to go through the charade of saying there was consideration or there wasn't consideration or there was nominal consideration. And of course, the area that is of particular interest to me, because there's been some recent case law around post-contract modifications. So as a result of the 2007 financial crisis, and the foreclosure crisis, and those of you who know me probably were waiting to find out when it was I was going to start talking about mortgage foreclosures. So one of the things that has happened is that several million contracts, loan contracts, have been modified. And these modifications are one-sided in the sense that typically the borrower who had agreed previously to pay, let's say, 6% interest on their loan is now going to pay 2% interest. And they're not promising to do anything more in return. So the classic consideration doctrine would tell us the promise to pay a lesser amount for a debt that you previously owed a larger amount on. That's not a promise that's supported by, that promise doesn't provide any consideration to the other party. And of course, the restatement, second of contract, section 89, says, let's forget about consideration, or let's at least think about alternative ways of thinking of post-contract modifications, and say, if there's been a change in circumstances, if this is good faith, if the parties in their contractual relationship have decided it's advantageous to both parties to change their previous obligations, the fact that one party is not contributing any more to the deal shouldn't matter. As long as we don't have coercion, duress, the other kinds of things we worry about, the Alaska Packers scenario, modifications should be enforceable. Well, what has happened, in fact, is that so many large mortgage servicers have embarked on these wide-scale promises to homeowners saying, well, if you make payments to us, lower payments you were making before, and if you do this faithfully and reliably for 3 months or 6 months, we promise that we will agree to accept less money than we originally wanted. We will agree to reduce your interest rate, for example, or extend your payments. And it turns out, and this was incentivized by payments from the federal government, among other things, it turns out that a number of the large banks have decided to renege on these agreements. And after promising to modify people's loans, 6 months or a year later, they unilaterally reimpose the original terms of the loan. And this behavior seems very unfair to the people involved, not surprisingly, and to some attorneys who have brought lawsuits, including some class action lawsuits. And one of them resulted in a decision in the Seventh Circuit in which the panel goes through an analysis of whether the homeowners have provided consideration for this post-contract modification. And what's striking to me, there are now a couple dozen of decisions in the federal courts and the state courts on this question of whether these promises of mortgage modifications need to be supported by consideration and whether they are supported by consideration. I have yet to find a single case that mentions the restatement section 89. And this came to my attention actually because some lawyers litigating these cases contacted me about some consulting work in connection with these class actions. I said, well, what about restatement 89? And the lawyer said, pre-existing duty here in Massachusetts or here in Nevada or wherever they're litigating it, the courts have not even begun to think about modifications in the way the restatement, I think, in this context, encourages them to think about it. So instead, we go through this exercise where courts ask, are these homeowners doing something they previously didn't agree to do? Well, they're providing financial information, they're filling out some paperwork, they're doing some forms, all of which strikes me as fitting in the category of conditional gift rather than actual consideration. But be that as it may, the courts, including the Seventh Circuit, are saying, yes, these modifications are enforceable because we can trump up some kind of consideration in this deal, even though in reality, they're one-sided contract modifications. And that strikes me as just, a huge waste of time, not a useful exercise for courts to be engaged in. And doctrine is going in the wrong direction if we're still stuck thinking in those terms. So part of what I propose to do in the paper is to just canvass each of these particular doctrinal areas, the rules on binding written offers, on enforcing purely gratuitous promises based on reliance. I think promissory estoppel is nearly universally accepted, but that's certainly something I want to check on. But I think when we think about both charitable subscriptions and gift promises in general, consideration is just not very predictive of how courts analyze those problems. So you have to go through the consideration, analysis, the litany, invoke the principle, and then go on to decide the case on other bases. The same thing with promises for past benefits received, with third-party guarantees, with post-contract modifications, less so, as I said, and illusory promises. So any area in which you would think a court would refuse to enforce some kind of promise or some kind of modification based on consideration, there is an alternative rule. And my suspicion is the alternative rule is either gaining ground, or if it's not, it's because courts are just deciding these cases incorrectly. Okay, now, what about consideration and contract theory? I mean, a theory obviously has to have some role in our teaching. When we encounter first-year contract students, typically in the first semester, we want to share with them some general ideas about jurisprudence, some ideas about, why laws are what they are, about things like law and economics and law and society and other perspectives on the law. How does consideration fit into all that? Well, not particularly well. We have famous Charles Freed's Contract as Promise that Professor Barnett has sort of taken up, the idea that contract is about autonomy, it's about voluntary obligations. None of that suggests that an exchange is a necessary part of a contract, right? The consideration doesn't really play any role. In fact, I think Professor Freed explicitly rejects the idea of consideration as a theoretical basis for why to enforce promises. Then you have kind of the compensatory justice theories, the ideas that we need to either protect people's expectations or compensate them for harm that's been caused because their expectations have been dashed or because of their reliance. And there too, it's perfectly possible for people to rely on promises that are not part of an exchange just as much or more perhaps as parties to fairly casual mercantile type transactions. And then what do I want to call the consequentialist theories, the theories that say, well, we should enforce promises because it's good for society, because it contributes to the greater good. That's sort of the consequentialists. The utilitarians are sort of a subgroup of those, and the law and economics efficiency folks are sort of a subset of those. But there too, most of the people who think about law and economics are willing to concede that gift promises and other gratuitous promises make the world better off. They're Pareto efficient. For example, just to take one example, a wealthy donor promising to give money to a charitable institution because of the diminishing marginal utility of money, right? The money is worth more to the poor people who are going to be helped by the charitable institution than it was to the rich person. They don't consider themselves worse off by making the donation. Sometimes they get some psychic benefit from it, and the world is better off because of the donation. I mean, there's just no coherent connection between the idea of exchange and welfare maximization, although that was sort of the old, more crude justification for the doctrine. So contemporary contract theory, I haven't found one. I mean, there are a few articles that defend consideration theory. They're out there. People have given it their best shot. But they're not really very convincing. So then the question becomes, okay, what are we going to do when we teach this class where we have these case books where chapter 1 is consideration? Well, my suggestion is that a number of the specific problems consideration addresses can be relocated to other parts of the curriculum. And then we're going to need this little residual piece where we talk about purely gift promises or gratuitous promises and, you know, the old doctrine of consideration, which should go alongside the doctrine of contracts under seal and, you know, the law merchant and other things that maybe we should mention, but we should certainly not give undue weight to. So, you know, obviously binding offers, that's part of offer and acceptance. Promises for past benefits, reaffirmation of discharge promises. We can fit that, I think, pretty well into quasi-contract and restitution. Likewise, well, modifications, that's post-contract stuff, right? Post-contract modifications fits in with performance, modification, breach, waiver. Very natural place to talk about it and about the values behind allowing them or not. And so I think there are other places in the curriculum to do this. And I think what you need ultimately is to have a little unit that talks about classic non-exchange transactions, promises of gifts, and to say there was this old doctrine of consideration, but now we have new ways of thinking about whether we enforce those promises or not. Okay, thanks, and sorry for going over a little bit. Yeah, let's see, which ones?
I'm going to be fairly rigid on time.
Where are
We
you?
got started late on the last panel.
This
Yeah.
one, restitution, right?
This wasn't working.
You know, at one point it was working and then it stopped working.
Is that working? Don't time me yet. All right, I'll start talking fast because I realize that, okay, which way to go, that way? Okay, I'm talking about teaching in the digital age. I am not a PowerPoint person, but I had to do PowerPoint. So I'm going to try and do this. I'm really sort of snuck in here to talk about teaching contracts, and I'm going to focus on why I think it's so important that we start teaching in a different way. And then Lucille, who comes after me, well, actually, she's gone even farther in the gaming area than I have. So I'm going to skip through some of this because I realize that I'm not going to have enough time. But in my paper, what I did was I originally started talking about how we've always taught contracts and torts and property, and we did it through ends of court and through the earliest law schools, but I realized that I can't do the legal history part. Sorry, Jamie. So I'm going to have to start talking about modern day. We pretty much teach students the same subjects we did back in the 1700s, the same ways, although we've developed more new ways. And, you know, it's really interesting. When I was doing this research, I found reference back to teaching Socratically in the 1700s. So, you know, it was interesting to me that Langdale wasn't the one who started it. So I want to talk about how we should be, I think, educating students in the third millennium, because I think times are changing a lot. And I have to say, it took me a long time to come to this realization. And the way I did it, I don't want to get into the laptop versus no laptop, but I was one of these people, if you use the internet, you use Facebook, you use it in my class, your grade gets lowered. And they kept using it anyway. And I said, your grade's getting lowered. You have to sign something. But they couldn't stay off of that. And I sit behind in a lot of classes, and I watch them, you know, shopping for bridal gowns, and they're playing poker, and they're having a great time, but they're, you know, they answer questions. And I started thinking, what makes students, our students today, act like that when it's going to hurt their grades? A lot of students are very motivated, right? And they're usually motivated by grades. So I thought, okay, I'm obviously a dinosaur, and something's got to change here. So times really are changing. Students do things differently, certainly than when I went to school, but even, you know, in early 2000, I remember having a student who used a laptop in class, and all the other students complained and said we needed to ban it. That's only 14 years ago, which is pretty amazing. So if you look at some of the statistics that we have here, the statistics will, I think, really sort of show a story. And I use Pew a lot in this because I think Pew is particularly helpful. Pew is sort of a think tank that just studies the internet and how it's changed our lives and what it means to us. And I think it means a lot to us as teachers. So if you look at, in terms of where we are now in January of 2014, all of you probably have at least a couple of these, from cell phones, smartphones, e-readers, and our students are using all of them. I have all of them. I don't really know how to use all of them quite so well, but as you'll see, I'm trying to learn. So it's just multitasking, right? That's what everybody says. We can all multitask. And you know, I think we really can do a lot of multitasking, but I don't think that somebody like me can multitask in the same way as somebody, say, in their 20s. And as I started to do this research, I realized that it's actually different when it comes to learning. I'm going to sort of talk a little bit about the research. I'm going to talk a little bit how they've actually started doing MRIs and scans on brains to show people that are, especially our students who are coming today, their brains are actually changing. They've done MRIs to show they think very differently. And I try to get my students to understand that, and the only way I've done it, I've actually found some research that shows when it comes to learning, especially critical type learning like we're teaching, multitasking is really quite different. I'll just quickly, these seem like no-brainers to me, but my students didn't believe it until I pointed to the studies. So, is this the next one? No, let me go back here, sorry. Because again, I'm not wired in my brain. Junko and Cotton were some researchers in 2012, and what they did was they followed college students around almost 20 hours a day. Must have been really fun. And they watched everything they did, from eating to studying to being in class, and they found that college students who spent more time using information and communication technologies while doing homework, while studying, and they looked specifically at Facebook and testing, lowered their GPAs. And there was another one out of 2011, same thing. If they were doing instant message while studying or doing schoolwork, it lowered their GPAs. Another group of researchers, Wood et al. In 2012, found that using Facebook or instant message during a college lecture, then they gave an exam and they did worse on the exam. So I actually, you know, we do have these statistics to show that maybe not all multitasking is the same. However, we still have to think about who our students are. And the one thing I've come to understand is our students are just different. They're different than they were 10 years ago. They're different than they were 20 years ago. And what I'm worried about is teaching to these students, because I know that I actually did something so that I could tell whether or not my students were getting the material. My students are just as smart as they were 10 years ago. I actually looked at our statistics, our GPAs, our LSATs, we actually are the same this year, but they're not doing as well. I mean, I look at the numbers and they're not doing as well, and I'm trying to figure out why. And I think part of it is who our students are. Our students are, you know, not the baby boomers. There's this librarian out of the University of, out of New Jersey Institute of Technology, and he started doing a lot of research because he would come out into the library and he would see that everybody was constantly going back and forth from a computer to a game to studying to using the library. And the research that Richard Sweeney has shown, and he's done like focus groups and research in about 30 states now, was that we have this new generation that actually grew up doing things very differently. And you can see them called Net Generation, Generation G, the millennials. But this shows, I think, how different the differences are in our generation and online activities. And if you look over to the left, to the online teens, those are the students we're having now, because this is about 2008. 93% of them were going online. You come up to those of us who teach, we're probably somewhere between 82 to 79 to 70. And look at I'm going to start focusing on games in a minute, because I'm going to talk about that as a way to try and engage our students and get the doctrine across. But if you look on the very left side on online teens, you'll see that how many are playing games online. They're huge. They're really large percentages. They go back and forth as they got a little older. They like videos online, and they start using the internet a little bit differently. This is one of the Pew findings over the last 5 years. If you see where mobile phone use by teens, I was surprised that only 45% had them back in 2004. The only statistic I could find, at least the latest one, was 2010 from Pew, and that came up as 75%. So I think the fact that our students are constantly using all of these, the cell phone use is catching up to adults here. You can see, again, where the bottom line are the blue lines, the teens, and the top lines, the adults. It's really starting to, they're starting to catch up, and they're actually starting to overtake us. So then I started looking at these studies, and Pew in particular followed college students around, and they indicated that there was this high level of gameplay by college students. The interesting thing to me was at the college level, the kind of games that they're playing are more the one-on-one, the solitaire. Maybe that's because they can play that one in my class, I don't know. Crossword puzzles, poker, billiards, but not really the multiplayer and the big virtual world games. And they've shown within the last few years there's been a tremendous growth in gaming. For one segment of the population in particular, and that's college students. And what Pew said was they basically, right now, gaming is virtually commonplace. They use computer videos, online games. They're basically sort of woven into the fabric of their everyday life for college students. All of the students surveyed had played a video, computer, or online game at one time or another. 80% of the college students reported playing video, computer, or online games at least once in a while. The interesting piece to me is that they're not playing games all the time, right? It's not like they're just going there like the picture I had where you're constantly playing a game, but they use it as a distraction. So they use it as a socialization. So they'll study for a while and then they get distracted and they multitask and they'll play a game. So I started thinking, how can I use this? What does that mean for us as legal educators? I've been teaching contracts for 25 years, maybe a year or two more, and I started thinking about I need to reach my students differently. I think it's really important if what we want to do is to engage our students, and I don't know any law professors who don't want to engage their students. I think most of us care very, very deeply about it. And I think if we talk about games, and I'm going to talk about sort of a lower level games, and Lucille's actually gone, hers is better than mine because she's gotten to the digital game that I haven't, mine, I'm not as wired as she is. But I think with the college students that we're getting of traditional age, that we need to start thinking about different ways to teach to them. So I think what it means for our children, for our students, is that we do have this generation of students that their brains are wired differently. They multitask and they can do a lot of that. They don't realize that maybe with some of the critical thinking it's not as good. But I think we can just harness that. So instead of saying, you know, I don't want you to use this in my classroom and I just put your computers away, which I still do a little bit, but I want to try and harness what they're doing and use it so that I can get them to learn better. So if you happen to be in the talk yesterday that Deb Cohen talked about, she talked a little bit about this digital native versus digital immigrant. It's actually very important. I am clearly a digital immigrant. I have come to it kicking and screaming, but I have all the same things that my students have. I just don't use them the same way. The reason this is so important is that they learn differently. Digital natives get information, they prefer getting their information and learning from multiple sources. They're used to multitasking and parallel processing. This is basically a native speaker of technology who grew up fluent in digital languages of computers and video games. That's not me, and that's not most law professors. We're usually digital immigrants. We like our controlled release of information from a limited number of sources. We like getting it from text, and we need to realize that we got to start providing the information in a different way. Students, these are our students, right? They're the digital natives. I'm sorry, I know it's okay because my dean pointed out to me this was the 7th inning stretch and you can use a computer then, but he's a lot younger than me. Because to me, taking a computer to a baseball game, that was sort of surprising. That's a pretty common sort of picture. So the question is, we've got to think about the classrooms they came from. And I know this is a very, very busy slide. I liked it because, and I'm going to have it in my paper, because it talks about the 21st century classroom that the students are coming from. And I think we need to realize they're used to open source textbooks, they're used to integration of social networks, online courses, and this whole idea of gamification. So one of the reasons I think games are so important is I'm going to talk about the things that I believe games do, and I'm going to talk a little bit more about other disciplines that are using games. But we can actually increase student interaction. We can really do a lot of experiential learning and increase learning options across the board. The more learning options we give our students, the better we can be. And I just, sorry, like this slide. So why should contracts professors adopt gaming as a teaching tool? Well, I think there are a number of reasons that we ought to be doing that. We can use the tools to engage, to teach, to really get to our students. Not all students will work for, games won't work for all students, but they'll certainly work for a lot of our students, probably maybe 60 or 65%. And if I can get to 65% more of my students, I want to be able to do that. There's a number of studies, and I have 5 minutes, so I'm not going to have time. I do this all in my paper, and I actually have all this information that I've looked at the research on the studies in terms of what the games actually do. We can teach them the doctrine, contracts, first year, first semester. We know they've got to start with the doctrine. We can also then take the games. I use games right now like crossword puzzles and trivia games to help use the doctrine. Then we can take it to the next level where I've started to create digital games, and I will say Lucille has created a digital game on contracts, and we can really use them, I think, in a way that's really very helpful. What I'm going to do here is just show you some of the screenshots and some of the games that are happening, for example, in medical schools. The doctors, I hate it, they're way, way ahead of us. And they've actually done studies to show that the medical students like to get their information this way. They, at least 80% of them on the feedback show that they've really learned a lot from them. So this is an on-call game that actually reviewed the whole first semester of medical school. And students went in, they could talk about different kinds of situations and were able to answer a lot of different questions. Non-trivial pursuit, who wants to be a physician, who wants to be an attorney, right? I mean, those are a lot of games that I think we could make. This was one that I thought was interesting because back from '87, it was international. If you look on the left side, those are all the trivial games in the first list, and then all the microbiology and other medical games are listed a little bit farther down. This is one of the ones, this is what I'm working on. I'm trying to do a digital game that is basically on trivial, only I had to call it non-trivial pursuit. That's what the doctors did something, and this is basically a screenshot that allows our students to go in, play games. They can do it one-on-one. They can also do it in teams if they want. And I think they can have both the competition and it can help them. For those of you who are my age, it's also good for us. Just thought I'd tell you. That was it will help slow our mental decline. And that's why I started playing games. The other thing is the American Federation of Scientists, they are way ahead of us. They started doing this 15 or 20 years ago, where they have shown, and they have the research that I cite in my paper, that it really does support strategic and analytical thinking. It's not just about rote learning, although it starts with that, but it's problem solving, it's decision making. Some of the attributes I think that games offer, and one of the big one, I only have 2 minutes left, so I'm not going to be able to go through the rest of these, and I don't want to go over. But the other thing that's really important is assessment. The ABA tells us we have to do assessment tools. I think assessment is important. This is assessment. This will allow us to assess quickly. It will also give students feedback quickly. We can't all write every single paper. I have 90 contract students. I don't have time. I do one practice exam, but I can't do them all. We'll be able to give a lot more feedback and get a lot more to our students. So these are the kinds of puzzles I've started doing. You can see that the research shows that the users have found them extremely helpful. These are groups across the country at the universities, NYU, MIT. They're all doing these games to teach project because they're showing that the research is our students are wired. We need to live with that, and we need to basically dip into it. Justice Day O'Connor's dipping into it in K1 through 12, so I think now it's basically time for us, and I don't want to go over. Thank you very much. You don't have to look at the paper.
Now, Candace, are all those sites in your paper?
Yes.
Okay, so, and your paper's available?
No, but it will be in a month.
Okay, great.
Well, it's a draft form if you want to read it in comment.
I'm too short for this podium, it looks like. So you might just see the top of my head when you see the actual film. All right, let me pull up mine. We're having a little problem with the audio. Seems to be we're getting some feedback because of all the microphones. So I may have to talk through certain parts that were already taped. But as Candace pointed out, serious games, sometimes you'll see that word. That's just another word for educational games. It doesn't mean they're somber, sad, and depressing. It just means that they have educational objectives rather than standard gaming objectives. And I was fortunate enough to be involved with 2 projects. One was an Infolaw technology grant where the school that I work with put out a technology grant for people who wanted to do something different. And myself and some of my peers from the Phoenix School of Law, what we did is we put together a browser-based game called Simulawyer, and you'll see a little bit of that today. And then from interactions with my students who said, oh, you mean I have to sit at a computer? Oh, that's just too much work. How come it's not on the cell phone? I said, well, let me try to come up with something, because it's very different. Some of the things are different you have to do on a cell phone than you might in a browser-based game. So I just published it last month. It took about 10 months, and the simulator game took over a year to do, to publish it. So I have a sort of a beta version on here, but we've just finalized it in January. But we'll talk a little bit about this issue. One thing to keep in mind, I often get really irritated when people say to me, because they know I do work in the area of gaming. My background is technology. I teach cyber law, so I love laptops in the classroom, so I'm kind of the opposite person on this. But play as a pedagogical tool, people will say, oh, edutainment, infotainment, oh, we don't want any of that. Recognize that there are studies out there by those who actually study the field, that play is very important as a teaching tool. That as soon as you make something playful, people become immersed in it. And immersion is what you want if you want student engagement. You want people to get immersed, where they look up and say, wow, I've been doing this for a half an hour, and I didn't even realize it. Rather than, oh, this is drudgery, I'm just working my way through this. So part of active learning is this notion that play is actually a pedagogical tool. It's not the only one. It's part of sort of your entire toolkit that you might have as an instructor about active learning. And for a lot of us, I've been in the teaching field a long time, as well as what Candace has been, objectivist thought was the idea that you had the professor behind the lectern delivering information, words of wisdom, sometimes referred to as sage on the stage, the all-knowing professor giving you information. And that was when students were much more passive recipients of information. And in that particular environment, it's this idea that everything's sort of a one-way communication. And that might be true for a lot of us who are baby boomers. For example, when we were watching television, it came at us. Now you can watch shows where people can live tweet what's going on during the show, which we would never have done because that's more interactive. So we're moving away from this kind of one-way approach to communication to things that are more interactive. And there's pedagogical theory that supports that. Cognitive constructivism is this idea that if you are going to be an active learner, you're not just a passive recipient or receptacle of information. How you learn is that you subjectively interact with materials, interact with information, and from those personal experiences, you construct knowledge. So we always say students should take ownership for their learning. We hear this all the time. Well, that's what cognitive constructivism is. You take ownership because you are interacting with the material, and from that you are learning, and then you are building the structure for further learning, rather than I'm just listening to what the professor says, and some people I do say, with the laptops, I'll say to my students, you're not in a stenography school, don't write everything down that I say, capture the main essence. And I think when you actually have the student interacting with the material one-on-one, then you don't have that stenography, you have them trying to learn the material. The digital native, this has been around for a while, and this is this notion that I'm not a digital native. I grew up in an analog world with rotary phones and the VHS, so I thought that was the end of it, fantastic, that's as far as technology will go. And now we know, even from my own experiences, when I was in technology, we'd come out with a new software program maybe every 2 to 3 years. Now they come out every 6 months. So it's accelerating at a pace that we're just not perhaps ready as professors to adapt to, but that's the reality. The technology is moving us forward. Our students, most of them have grown up with digital technology. And so they're different from us, not only in the learning, but how they approach the information. Most baby boomers like myself, we got a book, we read the book, that was it. Most students today like to customize the information they receive. So they're more willing to manipulate content than they were back in the day. I know, for example, myself, when I want to do something, I like to read the instructions on a game. But when I look at my nieces and my nephews and they don't read instructions, they go and explore the game to figure out what the rules are. That's a different way of learning things. That's a different way of learning things. And most of our students are very comfortable with all of these digital platforms that some of us may have varying degrees of comfort with. And so because of that, and there are so many different platforms, it's interesting now if you go to a restaurant, there'll be somebody, they're all sitting at the table, somebody will be on a cell phone, somebody might be on a Kindle, somebody might be on an iPad, all these different, they're not talking to each other, God forbid, but they're all on these various devices, right? Because I think we're sort of slaves to our devices now. But all these different tools and platforms are available now, and they're not going to go away. We're not going to go back to the time period where it's just a book anymore. And so I think we have to adapt to that change. Also, a couple of years ago, I went to Wisconsin for a Game, Learning, and Society symposium. They've had them for a number of years. And most of the people there were K through 12. And some people from colleges, and I think I was probably the only one from a graduate institution. And you've got to realize that at these earlier grades, they are already using gaming. So there's a tsunami of people coming our way that are comfortable and will expect this kind of experience in the classroom that we might not have had before. And if you look at, for example, the average college student today does less than 5,000 hours of reading, more than 10,000 hours playing video games. TV's still the winner, though. 20,000 hours watching television. It's a much more visual generation, so we have to think of how we're going to engage these more visual learners over time. I think for all of us that are in legal education, we have to start to think about how are we going to help our students be more active learners? How are we going to deliver the educational content? How are we going to make this more accessible? I have, for example, I use Lexis, but I also have a learning management system at our school that we can use. And a lot of my peers will say, I'm not giving anybody the slides until after the class, because then they won't come. And I always say, that's crazy. Put the slides up before class, because I find most of them don't review it anyways. But they just like to know it's there. You know, so if it's accessible, that's good. So sometimes I'll ask a question, I'll say, that's on slide 3 if you actually read the slides before you came to class. You know, so that sort of thing. But keep in mind, that's the idea. People just want to know that they can access this if they want to. If they want to. So we've got to think about how are we going to deliver this content by the device? What kind of designs are we going to use to make this content more interactive? And what kind of experience are we going to deliver? You look at this old computer here, and now the next thing they're talking about is bracelet cell phones, where everything's going to be on your bracelet and you're going to be tapping there. So we have to work on that as legal educators. As Candace pointed out, we're kind of last to the party on this, and we always are, I'm sorry to say, but lawyers tend to be a little more conservative. And so they're already doing this in medical schools, they're already doing this in engineering schools, they're already doing this in the military, they're already doing this a lot of other places. So if our view is we're going to hold back the tide of technology, it's just not going to happen. So how can we then use that to engage our students? How can we use it? 2 games that I worked on, one is a program manager, that was the Simulawyer game that I worked on with my colleagues at the Phoenix School of Law. It was a browser-based game. We picked that on purpose because students have so many different kinds of phones. It would have been very difficult to come up with all these different kinds of platforms that we would have. You know, some people have Droid, some people have the iPhone. You know, it would have been crazy. So we thought, well, everybody's got a computer pretty much, or a laptop. So we'll make it a browser-based game. We did work with a company called Filament Games, and we had $50,000, which you might think is a lot. They told us that was like nothing. $50,000, I don't know we can give you for that, right? So it's an expensive proposition to do if you're going to use an outsider. Filament Games actually worked with Sandra Day O'Connor in her iCivics project, where she put together a lot of games to educate people about government and governmental structures. So we knew that they came from sort of a good pedigree. And Simulawyer was the name. We did a contest at the school and said, give us names you think would be good for this particular game, and a bunch of students replied, and the student, you know, who got the answer selected got like a $50 gift card or something. So it engaged the community in it and also increased awareness about the game. But the game is basically contracts, but there are also elements of professional responsibility in it, and professionalism tips, and exam taking tips. So we did a lot of things with contracts at the core, but we looked at professional responsibility issues you might find in a contract environment. Now, of course, they're going to be using mouse clicks for this, but there are matching questions, multiple choice, true, false, sorting, kind of offer, acceptance, consideration, you know, which one is offer, which is acceptance, which is consideration. After we spent like a year doing this, I had a bunch of students say, well, we'd like something for the cell phone because we don't have to kind of drag out that computer all the time. And that makes sense. I mean, casual gaming is on the rise. I see people playing Candy Crusher and Jewel and all this sort of stuff, right? These, even solitaire, that's hung in there. Solitaire's hung in there, right? Casual games are things you might do. Say you got 5 minutes between class. You know, you want to distract yourself, or you're waiting for the bus or the subway, or you're waiting for friends. that 5 minutes could be a learning opportunity. That's what I want to pass on to my fellow professors. And so if you're saying, they're always on their phones, well, then make something for their phones, and maybe they'll be using things that we want them to learn about. So that's the other thing. And so the mobile app, which I said we just put on Google Play, I'm very lucky. My husband's a software developer, so he helped me. But we also had to bring in some outside help because this stuff is very complicated. We did use a platform called Game Salad. And so Game Salad is a game that is a platform that you can import to a lot of different devices. So you can import it to the Kindle, the iPhone, Droid. So it's something, you don't have to have programming skills. It helps to have programming knowledge, but it's not, you're basically putting things into, that's why they call it Game Salad. You're putting things into the salad and they're mixing it up for you. So it is a do-it-yourself. So those of you that might want to do this is something that can be done, and there are platforms available for it. And this is screen taps, although you'll see on the videos I'm going to show you, I had to use mouse taps. It's the only way I could really tape it effectively. But it had 2 modes, a time mode, a 5-minute mode. We started with 10 minutes, and we could see that was going to be too long if it was going to be a casual game. So a 5-minute mode, and then a completely untimed mode, which means if you're a student who wants to go through, there are 200 questions in it. If you're a student who wants to go through it untimed and review it, that's fine too. And we called it Contracts is a Beach, in part because it's Florida, but students also tell me that Contracts is a beach. And so they really have a hard time with it. So I thought we'd play a little play on that. So it's fill in the blanks, multiple choice, and ID, okay, identifying things. I'm going to play the video. I think the sound's not going to work effectively in this room, so I'll probably just talk you through it to give you a little sense of it. Let's see if we can go back here. All right. Nope, it's not going to let me play my video. There we go. Just had to go higher up. Now this has music and the like, but you're probably not going to get it here because of the issue we're having with it. But this is sort of the screen that you would come onto for the Simulawyer game.
Actually come to this.
Oh, it is going to play.
If you click on
All right.
game. This was a contracts game that I put together with members of an in-the-law task force. It's a contracts game, but it also has questions on professional responsibility that relate to contract situations, along with professionalism tips and exam taking tips. Let's select Contracts 1. The student has the option of taking a tutorial before they play the game, so they can learn a little bit about the game before they start. They will click No for now. As you can see, you come into a law office. There are attorneys that are seated and that there are clients coming in through the door. As you can see, when this client comes through the door, he has 3 questions. Red is hard, green is easy, yellow is medium, for a total of 6 points. Let's open up this question box. Here he has a question about a classified ad and whether or not that's the basis for a contract. The student can click on the referenced image and take a look at the classified ad, giving them a sense of realism about some of the practical problems they'll face in the real world. We'll continue with that, and then we'll answer the question he's being asked about whether or not what his best arguments might be as to whether or not he would be bound in contracts. Stick that there for now, and we'll submit. The student test gives an incorrect answer. All the incorrect answers we can see are in red and are marked incorrect. C was the right answer. That's correct. Down below, we have the wise mentor. She'll explain what answers were right, what answers were wrong, and why. If the student wants to review the question again, they can click on this bubble, and it'll take them back to the question where they can look at the referenced image again. Close it out. And then review the wise mentor's advice once again. They won't be able to answer the question, though, a second time. We'll continue here. We're being asked now a true or false question. This was correct, and because it was correct, a student earned a prestige point. And the wise mentor appears to explain what was right, what was wrong. As we continue to the third part of this, we see that there are some additional facts that the student will read. They'll continue reading those facts, and then they'll get to the question. Offer, acceptance, and consideration. We have to put the right ones in. Was there an acceptance? Was there an offer? Was there a consideration? I'll just plot these in any old place for now to give you a flavor of the game. If the student decides, you know what, I'm going to change my mind, I want to trash that out, they get the chance to put them back in again. Again, the student can always go back and say, I want to take a look at those facts again. I think I've got that wrong. Let me answer it again. The student has multiple opportunities at it, but the time is ticking down in their 15-minute day. Oh, the correct answer. These two were correct. They're in green. This one was wrong. The offer was revoked before there was any acceptance. We'll say no to the valid contract. That was correct. Again, the student earns another prestige point, and then we continue. When the phone rings here, we can answer that for bonus points, but as you can see, there's a lot of things that they have to select. Maybe they want 4 points, maybe they want 14, maybe they want 6. But at the end of their 15-minute day, it will be determined whether they started at a junior associate and stayed there, or whether they got enough points to push them all the way up to managing partner. At each level, they get a particular emblem that ends up on the back of their wall here, so they can chart their progress as they go through these 3 15-minute days. But I hope that's given you some sense of how the simulator game is played.
Okay, so that's the that's the browser-based game. Now we'll see if we have any luck. We may be a twofer here on the mobile app. Oops, I don't want to go back every time. This one we may not be getting the sound on. There is music to this. Oh, maybe you are. It's going to work. I was going to say, call me later.
I'm working with a game developer to try to come up with a mobile app. Like casual gaming, it has some of the whimsical elements and bouncing ball and the beach scene here. And normally the student would be tapping on the right answers because it's on a mobile app, so it would be on a phone screen. But here we'll just click on the beach ball. We're still in the Q&A phase. We come to the terms and conditions screen. For our purposes, we'll just click on I agree. And then we come to
For our purposes.
Students then could review in a quick way a variety of concepts. Maybe they do it between classes, or maybe they do it while they're waiting for friends, or while they're waiting for the bus, but it's a way for them to, in a casual way, review the material. There is also a tutor or untimed mode in which the student can go through all of there's 200 questions here. That will help them to review these contract one concepts in a way that's not a race, but for them to take their time and to learn about each and every item. There's instructions down below should the student want to know a little more about the game, and then about us to discuss the game development tools and game development. But let's click on the time frame arcade. The question will come in. There are 2 stars in the upper left-hand corner. That means that there are 2 correct answers. If you go all the way to the right, you will see that there is a clock that is clicking down. And so that's a way to let the student know the times they have. You pick one. Why don't we select a second one as well? Those were both wrong. You hear that pow sound. They're both wrong, but it tells them what the correct answers were on the review screen. So it gives them the question again. It gives them the correct answers, and then it gives them an explanation. Let's do another question. Again, you see the question slides in. This one also has 2 correct answers. And here we'll just pick any 2 that come up. Those were wrong, but again, it gives you what the question is, what the correct answers are, and the explanation. Let's do one more. So this one's about the Corbin approach, which is a way of interpreting contracts. And so in this one, the correct answer here is permissive approach. So we'll try to give you one that's the correct answer so you can see what happens when the correct response is given. The Corbin follows the permissive approach. We have permissive.
Not fast enough.
This is also part of the fun of the game. You're going to have to click.
You're going to have to get it on time before it goes past you.
Otherwise, you're going to have to wait for it to come around again and time to click away. That was correct. You heard the correct sound. You see that it's the correct answer, and then there's the explanation. Let's quit now and see what our score is. So we got one right, so we're still at the lowest level, the turtle level. You go from the turtle level all the way up to the top level where you rule the beach, which is the shark level. But normally this is sort of a way to give you a sense of how you might make your own game, your own mobile app, to increase your students' interest in and understanding of your legal topic.
Okay, unfortunately, my time is up. At least it gave you a flavor of the two games. I also have the slides there, some of the things you might want to weigh as a professor about whether you want to do a browser-based game or a mobile app. But I think this is sort of the future, and I invite all of you as legal educators to join me in this adventure. So thank you.
I can't follow that. I'm not doing any PowerPoint.
Okay.
Most participants know I don't really talk in front of a speaker, so I'm just gonna.
The camera's up there, though.
Yeah.
Will I have it stand there? It'll be it's hard for me not to walk around the room.
It's gonna be on YouTube, so otherwise it would be like, great.
That's okay with me. All right. Okay, well, first of all, as most of you know or were told, I'm actually the Director of Academic Support, so my job's a little bit different than a lot of yours, where, you have a lot more responsibilities than I do, where I can actually spend a little bit more one-on-one time with my students as contract students and also as all the students for the 1Ls. I teach the 1Ls and I teach the 3Ls. And so I kind of see them at the beginning and I see them at the end. And so I kind of see that progression and what possibly we can do to actually help them at the beginning to then get them to the end. And I start every class of contracts with a motivational quote of some sort. One of my former students, David, actually sent me one last night. They always send them to me, and I usually start out. And I thought it was apropos for this conference. The difference between the right word and the almost right word is the difference between lightning and a lightning bug, and that's by Mark Twain. So in terms of contracts, I think it's a little bit apropos as to how you're actually constructing a contract. So as a first-year professor and a third-year professor, in the third year, I actually teach a pre-bar prep course. And when I speak to those students, the one thing that they do tell me is that they are most appreciative learning as much as they can in the first year as they can, so that when they get to the bar exam, they're not learning everything for the first time. It's hopefully that they're learning it or relearning it and reinforcing it. And so in contracts 1 and 2, we have 2 semesters of it, I try to really find this delicate balance between teaching the students how to read and think critically and how to apply and convey that knowledge, as well as teach the black letter law. And I know that that's like a, that's not, we don't like to say that, but let's face it, we do teach the black letter law to a degree. Now, Candace and Lucille, they have great things, and as academic support, I'm definitely looking at your stuff. Not inside, you don't do it in your class, correct? Yeah. Okay, yeah, outside the class. So ALIs, think about this. I know some of my ALIs are out there, so let's think about playing some of these games. Let's keep them interested. And so what I do is, and what I've done in the past, day 1, first day of contracts, Lucy v. Zierdt. I haven't done it in the last year or two, but what I do is I start the class. I'm a Gator, and so first thing I find out is where are my Seminoles, and as soon as I find out who my Seminoles are, those are my targets. And what I do is, and this is my whole point is really to bring it to life, bring contracts to life. When I started law school, I hated my contract professor. He was the most boring and mean man I had ever met in my life. And so while some of you are texting on your phones, I was doing crossword puzzles during contracts because I was going to get him, right? Well, the only person it hurt was myself, okay? Made up for it second semester, but contracts 1, not so much. We had our own way in our day how to not to pay attention to the professor. So what I do is I set up 2 chairs in the front of the classroom, and I am the cross-examiner. And so I find Mr. Lucy and I find Mr. Zierdt, and I bring them up and I place them in chairs. Now, in fairness, I make sure that they've actually briefed their cases, they understand the facts of the case, and I cross-examine them on the case. Because what I'm trying to do is bring that case to life. Let them know, why are we reading this case? What is going on in this case? What are the true facts that we're looking at? Now, I'm lucky enough to have a student instructor. We all are. All our first-year law professors do. So what I do is, as I'm cross-examining them, it's kind of a pseudo cross-examination. I bring up Mrs. Ziemer with Mr. Ziemer, because Mr. Ziemer doesn't always know the right answer. So he can look to his wife and ask her, the answer. And I bring up Mr. Lucy's brother, just in case Mr. Lucy doesn't know the answer. So, we try to keep it fair. And so what I do is I ask them questions, and the whole point of this exercise is to try to show the students, number one, why is this case here? And not only that, but what are the dispositive facts? What are the relevant facts? What are the irrelevant facts? So I'll throw out questions there that are completely irrelevant, and I'll have my student instructor object. And they'll object, and I'll be like, okay, why? And they'll talk about relevance. And so once we've gone through this procedure, what I do is then I ask the students to say, okay, now let's look at your briefs. Now, most of you, if you remember back in your first year of law school, and my students, I think some of them are in their first year of law school, your first brief that you ever wrote, right, was about 5 times longer than the actual case itself. So now what I guess my point is okay, let's cut out all the stuff that we don't need, and let's look at what's relevant and what's dispositive, because to me, that's probably one of the biggest problems that students face in law school, is really trying to focus in on what's relevant and what's not. And one of the biggest things that I tell my students all the time is, you shouldn't be spending all your time trying to figure out every single fact of that case, just in case your professor actually asks you a specific question and you don't know the answer. Because if you are, you're losing the point as to law school and what you're doing in law school. And I am a little bit of a dinosaur. I don't allow computers in my classroom, for multiple reasons. But I would say that the biggest reason I don't allow them in there is because I don't like that block between me and my students. And so because of that, you have to be able to engage them in other ways. And so that's the very first day. So at that point, my students are absolutely petrified of me because they're scared it's going to happen again. And it does happen again. And during the semester, throughout the semester, what I do is, when we come up to controversial cases, like the Pro CD case versus the classic, Gateway case, very, very similar facts coming to very, very different conclusions. And so what I do is I randomly go to students and ask them to come up and argue each side. And granted, they're very scared at first, but eventually they all start getting involved in it. And of course, you have to kind of, you got to play with it a little bit. And so if you bring up one person and they're floundering, what do? You just throw somebody else up there with them to try to get them to not flounder anymore. And then what you find, at first, like I said, it starts out a little bit rough, but as the semester goes along, as I do this, the students actually start enjoying it, and they start liking it. And then the students start becoming more involved. And actually, my ALI the other day, we did this exercise, and he says, I've never seen the class so involved before when you actually had them up arguing, because you had the other students arguing against them. And I think the reason that is because they're not intimidated by them. They're intimidated by me, but they're not intimidated by their peers. And so there's more of a discussion that goes on. And so for me, the whole point is, at least the point of my discussion right now, is really trying to bring contracts to life. And so these are the type of things that I try to look at to find, okay? So here's the big thing that I really wanted to talk about in this, because I'm going to make it short. The one major thing I do in my class is I do a law firm assignment. And what I do is I ask the students, put yourself together in law firms, anywhere from 3 to 6 people. And what I do is I give them a fact pattern. And we randomly put them on different sides. And what I ask them to do is to actually write their argument for their side. It's a pseudo appellate argument, but it's really a trial, because there's really all we have are facts. Because my goal is really to get them to learn how to write and how to write effectively and how to convey their thoughts. And so what I do is the very first thing that they have to do once they form their law firm is to create a collective agreement. So now they've been exposed to actually how to draft a contract. And of course I tell them, you don't have to draft it from scratch. You can find something, but make it relevant. And so once they do that and they come up with their collective agreement, I give them a week, they get together, and they write their actual, I want to say, it's loosely called a brief, but it's really in the form of how you would write it in an exam. And then what happens is I get them blindly, and I score them. And the top 3 briefs are now going to have oral arguments. Top brief are the judges. Second top brief represent the side that they were given. And then the third top brief takes the other side, whether it was a side that they actually had or not. And so what I have found over the years is that in the first semester, the best thing that comes out of it is that they're learning how to think. They're learning how to write. They're learning the material. They are getting together. They are putting it all together. And it becomes competitive. And from what my experience has been, it's always been a healthy competition. And it's scary, because this is going to be the first time the students go up and actually speak in front of their classmates. And they don't realize how scary it is until they actually do it. And so now the judges love it because they get robes. Okay, so they get to come in. They have their robes. The other sides have their argument to make. So what I do is I sit down with each one of those 3 firms, and with the judges, I kind of instruct them as to where their weaknesses and strengths were, what kind of questions they need to be asking, and then what I do is I get my 2 and 3Ls to actually coach the other 2 sides. I don't know if this is a coincidence or not, but all but one of the moot court executive boards are my former students, okay? And so, but the wonderful thing about it is what it brings out in the students and their excitement. I think their excitement in learning contracts, because let's face it, it's really hard to make contracts exciting, okay? I can't compete with torts, all right? So it's all about getting the students involved, getting the students where they should be in terms of learning the information and wanting to learn the information. Games are fantastic. They're a fantastic way of doing it, and I'm definitely going to try to incorporate this and steal it if I can, as much as possible, but you really can't do that so much in class. And so, and what happens is it bleeds into the second semester. And I know, because I have a group of my students back there, and I know they're all hungry. Y'all want to do it this year, right? You're all fighting to be the judges this year. You want to be the judges, or you at least want to be preparing, or at least representing one of the sides. And so because of that, I think what it does is like I said, it does a couple of things. It brings contracts to life. It gets my students writing. And that is probably one of the biggest weaknesses that we have just in this generation, okay? Let's face it, we have the generation of no student left behind. They haven't written a lot. They haven't written a lot in their grade school. They didn't write a lot in their undergrad. And this is something that we have to kind of make up for. And so the reality of it is how do we motivate them to write? And like I said, I'm lucky in that I have a lot more time than a lot of other professors who have way more responsibilities than I do, because I start first week or second week, my students are writing for me. And I don't want to call her out, but Carolina is one of my first-year law students. She's been writing for me since the second week of law school, and she has continued to write for me. And you know what? She booked my class, all right? And then people around her started seeing the same thing. And be careful what you wish for, because it is a lot of work to be able to go through all of this. My colleague, Jennifer Martin, she does these amazing workshops at Friday mornings at 9 a.m. and they're showing up. Okay, so to me, in my opinion, getting them to learn the information, you got to make it interesting. You got to make it interactive. The games are great. Making it interactive in the classroom, not just making it about the professor, making it about the students. Have the students arguing against each other. Trying to get them writing, thinking, putting it together. Yesterday morning, Friday, we have spring break next week. I had 45 of my 55 students show up to a 4-hour review, okay? So the motivation is there, okay? We just have to keep them motivated. And like I said, at least I think for a lot of schools, you have your student instructors and you have active learning, or I want to say student, academic support. Try to utilize that as much as you can. Like I said, I'm a little spoiled because I can give them much more one-on-one attention and much more feedback. But there are other ways of doing that by having people write and then giving each other feedback. So if you don't find that you as a professor has the opportunity to give as much feedback as you want, then have your students give feedback to one another. Okay? That's really all I wanted to talk about. Thank you very much. I wanted to make it short and get you guys out of here in time.
Thank you. It would be wonderful to take questions, but lunch is already underway. I hope you will join our panelists and talk to them more about this. Let's give them a big hand. And we'll see you all at lunch. There'll be a talk by Robin West about her work in unconscionability. So we'll see you there.